people will say, well, why don't we challenge this and why don't we challenge that? And it's like, look, do you want to be the named defendant? Do you
Right.
want to be the guinea pig? Do you want to be the one that has to face a possible felony conviction and possible incarceration in prison? And so it's best that you just let these things rise up naturally.
We are the Armed Attorneys. Today we're talking about a case out of the state of Illinois that relates to the firearm owner's identification card. Now, this is that card where people in Illinois needed to have just to possess a firearm. We're not talking about a carry license. So we have a court finding it unconstitutional, but there's a little bit to it. So we're going to be discussing that, the facts of the case, and what this means going forward. But before we begin, show your support for the Second Amendment by hitting that like button. And so the case we're talking about is People v. Vivian Brown, if you wanted to check it out, 17 CM 60. And this was kind of a comedy of error. Well, I mean, not for her. I mean, she got charged criminally. This is terrible, but this is kind of a bizarre thing. But this happens more frequently than you'd think.
Well, I believe it started off as some sort of domestic issue because the police got a call that this lady had actually fired a shot in her house. Now, they don't say whether it was fired at somebody or not. So, of course, the police investigated. And after doing an investigation, they found that she was in possession of a rifle in her bedroom, but they could not determine for sure that the rifle had, in fact, been fired. I guess there was no bullet holes around to observe. And in fact, they spoke to two other occupants of the house who said that no such rifle was fired. And so basically, at that point, they had really no reason to charge Vivian Brown whatsoever. However, they did write up a report and they sent the report to the district attorney's office. So,
Yeah.
what did the district attorney do?
Well, I was gonna say, it's like, all right, well, show me the man, I'll show you the crime, kind of thing. I mean, this is stuff you would see in, like the Soviet Union. They had to get her for something, and so they charged her with this violation of not being in possession of a firearms owner identification card in connection with the possession of the rifle. This law came about in 1967, and if you wanted to check it out, it's 430 ILCS 65/2A1. And it says no person may acquire or possess any firearm, stun gun, or taser within the state without having in his or her possession a firearm owner's identification card previously issued in his or her name by the Department of the State Police under this provision of this act. It costs $10. From what I understand, it's basically a background check, but they kind of make this as a pretext. You need this in order to just possess a firearm.
You know what else came about in 1967?
Let's hear
This guy.
it. Oh man, a loss for the state of Illinois and a win for the state of Texas. But
Yes.
but they said so so she gets charged under this provision saying, hey, you don't have this firearm owner's identification card. Her lawyers, I mean, make some fantastic arguments because ultimately we have the court ruling this FOID statute unconstitutional, not just applied to her, facially unconstitutional, and that fee is also unconstitutional. And I think the reasoning is really where the sweet stuff is.
Yeah, her really kudos to her lawyer
Yeah.
because this is not the first challenge to the FOID card. I mean, there's been many challenges over the years, including a case that the state argues should be controlling here, a case I believe called State versus Gun,
Yep.
which they said that shows the FOID card's not unconstitutional. So why are we even looking at this issue again? And of course, her lawyer argued that, among other things, that it was a violation of the new Bruin standard, and the court found that it was. And then the court additionally looked at little things like the fee that you referenced, making an analogy that it was akin to a poll tax.
Yeah.
That basically, once they determine that you have this right to have this firearm, to put some sort of financial burden on the right is the same as financially burden somebody's right to vote.
Yeah, and the government threw out a bunch of arguments here that I think just so you know how crummy these people are. Part of that gun decision was, hey, when we write a law, you got to presume it's constitutional. I mean, that is the exact opposite of what we see in New York State Rifle and Pistol Association v. Bruin, which is, hey, if the Second Amendment is implicated, the presumption is it's unconstitutional. So we're talking about maybe binding Illinois precedent compared to the United States Supreme Court. Obviously, we're going to go with the Supreme Court on this one. And yes, there they were talking, and it really had more to do with the carry license itself outside of the home. And that's one distinction I want to talk about. I don't like how this court really pigeonholed itself into hey, we're just talking about self-defense in the home. We're not talking about carrying out in public. And so if we wanted to find any precedential value in this outside of the home, do you think this case would be helpful?
Well, yes, and I think that obviously it is frustrating, but this is simply the way that constitutional litigation works. Is you only litigate really kind of the facts that are in front of us, because the standard of declaring a statute facially unconstitutional is that if the government can come up with any circumstance, any type of scenario in which the statute is valid, then it cannot be facially challenged. It has to be an as applied challenge. And so you're forced to look at the facts that are right in front of you. It just so happens that that Miss Brown was, in her own home, in her bedroom. That's where the rifle was located.
She has no criminal history.
She has no criminal history, and so that's what the court was forced to look at. Certainly, I think the next step, in which it's basically the same thing as Heller.
Right.
Heller said you could that was about being in the home with a gun.
Yeah. And so the kind of crummy thing that the government then tried to shift to was, well, there's no difference between being inside of your home and being out in public. The FOID card, it makes no difference whether you're in the sanctity of your own home or out in public, which I thought was just a wild argument. And the court does a fantastic job dismantling this by showing the different standards for self-defense. There's a different standard inside of your home. Somebody forcefully and unlawfully enters, you think they're going to commit an assault. I believe that I'm paraphrasing here, fact check me. Outside the home, it'd have to be immediately necessary in response to a threat of serious bodily injury or death. So we see those two things are a little bit different. We give the benefit of the doubt to the defender inside of the home. Why do we do that? Well, because the home is more sacred. And so I think they do a great job of dismantling the government's argument that these are the two same things.
Sure. And obviously we would have preferred it, or it would have been more exciting if the judge basically would have called the state's bluff and said, hey, state, you're right. Home and outside are the same. No FOID cards anywhere.
Yeah,
but
we didn't
they
get that.
didn't. No, they didn't do that. Judges have to be more metered and more reasonable. That's left for people on the internet to say things like that.
Sure.
Judges don't say that.
And so what did, kind of go into the conclusion of what this judge found? Well, they properly noticed the state's attorney general that they were challenging the constitutionality of this. The court says, guess what? You met your burden. The Second Amendment is implicated by this. New York State Rifle and Pistol Association, the government hasn't proffered any historical analog to show that this is something that would have been regulated at the time of the adoption of the Second Amendment in 1791. This 1967 law, that is not what we're looking at here, and so unconstitutional.
Right. And keep in mind, this was a state court, a state circuit court, probably very similar to trial courts everywhere. So it will obviously go through the appeals process, possibly ending up at the Illinois Supreme Court. So
Yep.
keep in mind, this is not a federal case. Okay, so it wasn't challenged in federal court. This is a state criminal prosecution, and so it will be appealed through the state appellate processes.
Yeah, we've had a kind of good rash of cases that have been coming from criminal cases, and this is what we talk to folks about this all the time. How do we bring down this infringement or that infringement? And really, in a lot of these cases, the best place for it to happen is in a criminal court. But guess what? Nobody wants to, be in the hot seat and
Right.
have their liberty, deprived while this thing gets litigated. But we see a lot of action in criminal courts lately.
Oh yeah, and that's that is sort of a common phrase with many phone conversations we have around here. Is people will say, "Well, why don't we challenge this and why don't we challenge that?" And it's like, look, do you want to be the named defendant? Do
Right.
you want to be the guinea pig? Do you want to be the one that has to face a possible felony conviction and possible incarceration in prison? And so it's best that you just let these things rise up naturally.
Yeah, and so what does this mean if you're in the state of Illinois? Do you need a FOID card? At the time of the filming of this, the opinion had just been issued. I imagine this is going to be immediately appealed and stayed while they litigate it and appeal this up, as Edwin was talking about, maybe all the way to the Supreme Court. So, this information is going to be extremely fast changing. I imagine this isn't going to be up for very long until we get some kind of final decision.
Yeah, and keep in mind, this is this, like I said, the opinion does appear to be limited to the home. I think it's going to be more difficult to find somebody who is charged with not having a FOID card while carrying outside their house.
Yeah.
Because you got to have the carry license, and the first step in getting the carry license is to get the FOID card.
Right.
And so somebody who is caught outside their house, that's the first thing they're going to be charged with is not having the carry license. They probably won't even go to the FOID card. They may, but they may not risk it if this case is upheld in any of the appellate forms.
And I think what Miss Brown had going for her a lot was she was minding her own business in her own house. You know, if we have somebody out in public, I think there's a higher likelihood that they're going to be alleged to have been engaged in some other criminal activity. You know, bad facts make bad law. These are good facts. These are good facts that just kind of illustrate the ridiculous infringement that the FOID card is. So we really enjoy it.
Yeah, and I hope Miss Brown feels some sort of feeling of redemption after being unjustifiably rung through the system like this, because this case has been pending since 2017.
Good Lord. Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to leave us your questions and comments in the section down below. And until next time, we're the Armed Attorneys.